When I thought about perhaps saying some things that might not find very much agreement in this room, I was looking about and noticed these columns that prevent us from seeing all who are in the audience. And I'm reminded of a time when Judge Bork spoke before an audience that he wasn't sure was going to be totally friendly, and he said, the only good thing about speaking in a room full of a lot of columns is that the columns interfere with the line of throw. So I'll at least to be able to duck a little bit better. Also, Tony said that he was speaking without notes. I'm a lawyer. I am a lawyer, and I speak with notes because I found if I start talking at noon without notes, I'm still talking about dinner time to an empty room. So you can be assured that as I get through my talk, there is an end to it when I come to the end of my notes. So to give you a brief roadmap, I want to make 3 points and discuss them briefly before we turn to your questions. First, I believe that corporations, by and large, strongly prefer that judicial selection not be a political process and that it not involve election campaigns. I think we'll all be in agreement with that. Second, as a matter of self-protection, if not self-preservation, corporations must engage in the politics of some judicial election campaigns. And I'd like to use Mr. Caperton's case as a bit of a case study in that, to that extent. And then finally, corporations should play a significant role in our political processes. And I, again, want to emphasize that the views I express are idiosyncratic to me and not necessarily reflective of any of the organizations that I'm involved in. So the first point, the interest, I think, of corporations is to depoliticize the judicial selection process as much as possible. As Landon made clear from his experience, there's a very strong corporate interest here and abroad in promoting the rule of law, which includes having neutral courts with judges who demonstrate integrity and objectivity or impartiality in determining the facts and applying the law. In addition, corporations want judicial systems that are predictable in terms of following statutes and precedent, and that are efficient in terms of time and cost to get to resolution. So courts, as business fully recognizes, are essential to protect investment, intellectual property, and contract rights, and to reach fair and appropriate resolutions in contested matters, be they employment, tax, tort, governance, or whatever. It is indisputable that campaign contributions to judges create an appearance of bias, even corruption. All the surveys show that, all the personal experience and our own common sense tells us that. And even worse, we know the content and tone of campaign advertising in some judicial elections is very destructive of public respect for the judiciary as an institution and of public confidence in the court's ability to be fair and impartial. So I support, as do many current and former general counsel, merit selection systems which involve bipartisan nominating commissions and include periodic retention elections informed by meaningful appraisals of judicial performance. In fact, the U.S. Chamber of Commerce has even endorsed the Arizona model of merit selection as one good way to select judges and has published a booklet supporting that system. In states where judges are elected, I favor strong recusal rules to prevent judges from hearing cases involving substantial contributors, either as parties or counsel. I'm encouraged that the New York Chief Judge Lippman has proposed a recusal rule recently. The comment period ends at the end of this month, which would preclude a judge from hearing a case where the attorney or party before the court has contributed $2,500, far less than the $3 million involved in West Virginia, to a judge's campaign before whom the case would be assigned within the preceding 2 years of the case being assigned. I think $2,500 is a lot closer to the right threshold for recusal than the due process standard of $2.5 or $3 million, which finally got the Supreme Court 5-4 to find a due process violation. Now, again, I'm going to talk about Mr. Caperton's case from having read the decisions, not having lived it as he has for 13 years, or his family, and I know how difficult that is. And there's nothing that he said that I would have any basis for disagreeing with, so I subscribe you, and I'm not trying to in any way amend or alter your statement of the case, but I think there's another perspective to it, and that's really what I'd like to focus my remarks on. I think it's too complicated a case to develop in this type of panel, but it's important to note that Mr. Blankenship, the head of Massey Cole, poured his and others' money into this 2004 campaign to defeat then Chief Justice McGraw, and he did so largely as third-party expenditures, technically independent of the campaign of the challenger, Mr. Benjamin, but clearly helpful to Mr. Benjamin. Chief Justice Benjamin, who defeated McGraw, felt he could be impartial. He wrote an opinion to that effect, noted in refusing to recuse himself in the major decision that he had previously actually ruled against Massey Cole while in the court. And it's also important, I think, to realize there were 3 opinions in Mr. Caperton's case issued by the West Virginia Supreme Court. 2 before the United States Supreme Court decision and 1 afterward. A total of 11 judges ruled on the merits of Massey Cole's appeal, with 7 deciding for Massey Cole and 4 agreeing with Mr. Caperton's position for Harmon Mining. Specifically on remand from the U.S. Supreme Court, with Chief Justice Benjamin off the case, the majority ruling in favor of Massey Cole actually increased from a 3-2 split to a 4-1 majority for Massey. Now, even though all the judges who should have recused themselves did not participate in that final adverse opinion, I would sympathize with Mr. Caperton if he still felt that the ultimate ruling against him was indelibly tainted by the campaign contributions to Mr. Blankenship, and he's told us that explicitly in his remarks today. So why is his case illustrative in my mind of why corporations must play a role in state judicial elections, at least at times? Suffice to say, as he indicated in his remarks, the underlying claims that his company presented were for both breach of contract and tortious interference with contractual rights. Mr. Caperton's lawyer sued Massey Cole in Virginia on breach of contract claims because the contract stipulated that claims relating to the contract would be adjudicated in that state. After filing suit in Virginia, his lawyers filed their tort claims against Massey in West Virginia, which set up the legal issue that Mr. Caperton referred to as to whether the contract required the tortious interference claims also to be brought in Virginia. Mr. Caperton did prevail on his contract claim in Virginia and was awarded $6 million by that court. But in West Virginia, the ultimate ruling of the 4 justices in the final opinion was, as he indicated, that all claims relating to the contract, including the tort claims, were required to be litigated in Virginia, thus reversing the initial $50 million award to Mr. Caperton and his companies by the West Virginia jury. So I ask you, and I ask myself, why did Mr. Caperton's lawyers split their causes of action and sue in tort in West Virginia? Only they can answer that. But sitting as an outsider from the bleacher seats, my suspicion is that they recognized, as good lawyers would, that there was much more favorable law, including the availability of punitive damages in West Virginia. And in fact, punitive damages were part of the $50 million verdict. Also, West Virginia at the time had a reputation for being very pro-plaintiff, especially in tort cases. And the Supreme Court of West Virginia was viewed similarly. Had Justice McGraw won re-election in 2004, I have no doubt that the jury award would have been upheld by a 3-2 margin. So to that extent, there's no doubt in my mind that that race made the difference in the case. But it was not necessarily because Mr. Benjamin was swayed by a sense of loyalty or payback to Blankenship. Remember, it was 4-1 even after Benjamin was replaced. But because McGraw had been an almost sure vote to sustain any plaintiff's verdict. And he was the one who was booted off the court in the 2004 election. So with this case in mind, I step back and describe what business was facing and still is facing today in some state court jurisdictions. In some states, there are a few local jurisdictions in which an out-of-state corporation could not get a fair trial and would not be accorded fundamental due process. Exorbitant settlements would be extracted with pressure from the court, and if a company resisted that pressure, it could count on being hit with a gigantic damages award. Its only hope, if it did get hit with a large verdict, was for a meaningful and fair review by a state appellate court, usually at the Supreme Court. But in some of these states, the judges are and were elected at the Supreme Court level, perhaps all the way down to the trial court. 39 states have some form of election of judges. Business Counsel in the early 90s woke up to the fact that the trial bar, the plaintiff's lawyers, had been very smart in getting colleagues to run for these judicial seats, and their rulings often reflected a clear anti-corporate, pro-plaintiff bias. So we sat around as general counsel and said, what can we do as citizens and as representatives of our companies about this situation? We talked to people who are chief justices of various states, and they said, friends, this is nothing the courts can deal with. This is a political problem, a political process, and you're going to have to deal with it politically. So the tort wars were now officially underway, and they continue today. But unfortunately, still more special interests have joined the fray. The groups interested in particular social issues or management labor interests, as we saw in Wisconsin. So the court contests are really fundamentally political contests for control of the judicial philosophy and outlook of the court. The central question then for today's topic, so far as I'm concerned, is should corporations, recognizing the destructive effects of campaign contributions on public confidence in the courts, be to retreat and withdraw to the sidelines of judicial election contests? What if this means, as it will, that the corporation is apt to get hit with a $1 billion punitive damages award with little pretense of a truly fair trial and little prospect of meaningful review by the state Supreme Court? How well will we have protected the shareholder interests, those of our employees in the communities in which we do operate and pay taxes? The asbestos litigation is just one example of where these abuses in fact occurred, and Illinois was not immune. and dozens of corporations, literally dozens of corporations, went bankrupt because of the payouts exacted by plaintiffs' counsel in friendly courts. I'll make my final point in this section on the role of corporations in judicial elections by commenting briefly on the Wisconsin race and the recall that you may be aware of 3 Iowa Supreme Court justices following that court's ruling upholding gay marriage rights. In Wisconsin, whoever is declared the winner of the contested race, should that judge recuse himself or herself from hearing the lawsuit challenging the action of the Wisconsin legislature? Isn't the public sense that Kloppenburg is certain to vote to uphold Prosperous is certain to uphold the legislature, and Kloppenburg is certain to strike down the law? That's just the sense from the way the election was conducted and how the money flowed in. And isn't it because of the special interest money, the third-party money that flowed into those races from various groups that have a stake in the outcome of the case, and that colors the public sense of the likely outcome, almost inevitable outcome of the case? In Iowa, different situation. 3 justices were recalled essentially, and they did very little campaigning against a well-organized and financed political campaign to remove them. Every justice I talked to since then says that the lesson of Iowa is that as a justice, you have to campaign hard in the face of a recall campaign, and that means you have to have money. So in sum, as long as the Supreme Court holds to its view that money is speech and protected by the First Amendment election campaigns, interest groups, business and otherwise, are going to be in campaigns, campaigning hard to try to assure that particular judicial outlooks or philosophies are represented, especially on elected state Supreme Courts. Money can't be effectively regulated, apparently. Recusal is a help in terms of trying to retain public confidence, but the campaigns will still be costly and too often ugly and mean-spirited. And that is why transparent, bipartisan merit selection systems are to be vastly preferred over elections for judges, but also why corporations and business interests have no choice but to play a role in some state election contests. There's simply too much at stake if, quote, the wrong justices are elected. My final point is just to toss out some thoughts on the role of corporations in the political process generally, which is the topic overall of this panel. And I agree with Bill and Tony and many of their perspectives. Corporations have important perspectives, usually well-informed, if self-interested, about many policy issues which affect the well-being of the economy, the health of communities, the jobs of millions, and the competitiveness of the nation. Their views should be expressed and considered by voters or legislators in a democracy, just as should the views of labor, NGOs, across the political spectrum, and certainly individuals. Even more so than in most judicial races, it matters to the investments of shareholders and the jobs of employees if in some contests for the executive or legislative branches, a particular candidate wins or loses. It would be a serious mistake for corporations to unilaterally declare a retreat from political debate and contests, leaving the field of battle and the floors of the legislatures to anti-business interests. The president, here's where the throwing comes in. The president and the New York Times were wrong, in my opinion, about Citizens United and its likely effects, principally because corporations already were free to engage in and finance voter education campaigns. And so long as they did so other than to expressly encourage a vote for or against a candidate. Moreover, corporations, by and large, are not anxious to make political contributions, and for the most part, would prefer not to do so. So there's been no opening of the floodgates with corporations rushing to throw in money in candidate races. They could participate as much as they cared to or needed to before. I do agree with the point that was made here that boards of directors should monitor their company's political activity and spending, and that all direct contributions either to voter education or direct candidate campaigns should be transparent. But I don't agree that donations to special interest organizations, be they the Sierra Club, the NAACP, or the Business Roundtable, should be made public provided the donors do not control the organization's decisions about which campaigns to support and which and how much advertising to run, because of the likelihood that other special interest groups will try to mount pressure on donors to cease funding those groups altogether and to achieve their political goals indirectly through coercion in shareholder meetings rather than directly in elections. So I think, again, fundamentally the problem here that the Supreme Court's dealt us for decades is that money equals speech under the First Amendment in their view. So how do you control money without controlling speech? That's the fundamental conundrum. And I think that we now have the equation that plays out that money equals speech, and as Bill said, it equals access. And so I think the efforts of the group here in Illinois and the other organizations that have been mentioned to try to find some way in which we can take the public sense that money is what speaks in terms of how our government runs and the actions it takes is still a fundamental and difficult conundrum and dilemma for us. Thank you.